The next item is a request from an establishment, the Green Lady Dispensary, for a letter of non-opposition or support, that's the legal term, to the Mass Department of Public Health regarding the location of a registered medical marijuana dispensary at 11 Amelia Drive. This is a necessary step in their process to get licensed. And we have had town council work with them on a proposed host community benefit agreement. And I think there are some standard requirements in the law now for what can be in the agreement. And I think if the board is going down the road of either the letter of non-opposition or the letter of support, that the group has agreed to the benefit agreement.
That's correct. Good evening, Madam Chair, members of the board, Manager Gibson. Michael Wilson, attorney on behalf of the principals of the Green Lady Dispensary. It's Nicole and Rupert Campbell. And I have with me tonight attorney Adam Fine, and he is handling the state process for the licensure. What they're asking for the board to consider is approving their request for either a letter of support or the sample that you have on the display here, a letter of non-opposition for the proposed location to operate what the town is calling a medical marijuana treatment center, what the state's referring to as a medical marijuana dispensary. It is only proposed, and we are only asking for you to consider the medical marijuana dispensary letter of non-opposition. The address, the proposed location is 11 Amelia Drive. Some of you may have read in the recent newspaper, one of our beloved local dentists has decided to retire. So it's the location where there is presently and has been operated for many years a dentist office. Through this process, which we've taken a few months to work with the town, I'm happy to report that with town council we've worked collaboratively to come up, as Manager Gibson has said, with a mutually beneficial community host benefit agreement, an economic benefit to the town provided by your facility that's operational. There were two requested points that I think were still in question, and having spoken with town council, we've cleared up the fact that it is all in agreement with what has been proposed and what the Green Lady Dispensary agrees to do. We also worked with the planning department. I think it's a fair assessment to say that they believe the location, which is within eyesight of this building, of the public safety complex, is consistent with the long-term planning for the town. There are a number of benefits that I think were pointed out and could be potentially realized in the future for the 11 Amelia Drive location and its proximity to our town parking lot and our town public safety complex. We've worked with Chief Pittman, and I believe it's fair to say that we've developed a mutually beneficial and agreed upon security protocol and procedure. Four very important points that Chief brought up with the original draft, which were all contemplated, negotiated, and agreed and accepted. So I think the Chief will speak to that, but we have come to a very workable security protocol and procedure. I know there's a lot of discussion, and we had the initial presentation about the recreational regulations and the moratorium. This proposed location does sit within the CN zone. It is the zone that our town has already zoned, and that has certain ramifications for where you can and where you can't, and proximity to other types of uses. This location fits that. It's a location that we think, if the board considers, you would consider it favorably. I'll let Adam speak to the state regulations on that. I can also point out that the property is under agreement, so there is a contract for this purchase to occur. It's to occur at the end of the year, at the end of 2017. We have a PowerPoint presentation that I think may address or spur on a lot of questions, and Adam's going to author or guide you through that, but if there's any...
Yeah, I don't know if it's possible to have the PowerPoint loaded. Fantastic, thank you.
Go.
I think we'll hand it off to the principal, Nicole, to kind of introduce herself.
Nicole,
You want to go?
right here.
Okay.
Right.
Hi, good evening, how are you? I'm actually been looking forward to coming before you and telling you a little bit about ourselves. But excuse me, I'm not good at public speaking, so I don't do it often. To tell you a little bit about the Green Lady, I wanted to let you know a little bit about myself and my husband, Rupert, and how we got involved in this unusual industry, and how we can help with the medical needs of patients on Nantucket. We own another family business, Rupert and myself and my mother, and she's also involved in this, so it's a true family business. And what we do is we manufacture specialty fertilizers, micronutrients, organics, and biological fungicides that we sell across the country to different industries, vegetable growers, citrus growers, golf courses, and most recently, several years ago, we got involved in making a product line for the legal cannabis market. I had the opportunity to travel to states like Colorado and Oregon to learn from cultivators there, to meet with companies who make marijuana-infused products for sale, and of course, to visit dispensaries. We had a lot of learning experiences talking to patients of marijuana, of legal cannabis, and the good results that it had for them, very touching stories that moved us deeply about how it benefited them. And just to let you know, we have a long history with Nantucket. It means a lot to our family. We were actually married here 21 years ago at Brant Point Lighthouse on the 4th of July, and we haven't missed a 4th of July up here since. We also purchased a home in Surfside, and we come up here as much as we can, and we enjoy it very much. And we respect the community and all the parts of it, and we think that we understand it and can blend in a way that all of you will be very happy with, so that a year from now or 2 or 5 years from now, we can all look back on this and say it went well.
Well, I think she did just fine, public speaking-wise, and the PowerPoint presentation, I don't want to, there's a lot of details in there. Hopefully, Madam Chair and members of the board, that you have copies of it. I'm happy to, we'll try and move relatively quickly. I want to talk about some of the more compliance pieces, but more about the...
I don't believe
We don't have copies.
we don't have copies.
Oh, you don't? Okay, I do have some extra copies.
I'm going to apologize. It came in late Monday afternoon, and then I was in training all day yesterday, and I'd forgotten to load it up today.
Do you have copies?
Yeah, with your indulgence, I do
That
have
would be
5
great.
copies here. So this next slide that I'm going to focus on is just kind of giving the Madam Chair and the board a kind of a background of the RMD application process. RMD in the Commonwealth stands for Registered Marijuana Dispensary. It is referring only to medical. The state decided, the Public Health Council decided to change it from MMTC, Medical Marijuana Treatment Center, to RMD in the state regulation. So that is what, if I refer to RMD, that's what I'm referring to, a Registered Marijuana Dispensary, which is medical only. Just a little bit about the Green Ladies, kind of background in the application process. They have, to their credit, moved very quickly through the state application process. And this, there is one typo on there, but they started in June of 2017 with what's called Phase 1. That is the application of intent phase. That is a phase where you show that you're incorporated as a nonprofit. You pay a small fee, about $1,500. And you introduce your team, the board, and the team members. It's a perfunctory stage. It leads you to kind of the next stage, which is the management and operations profile phase, which they have successfully completed. And just quick summary of the management and operations profile phase, that is a phase where the state will look at your operational plans, a condensed version of them, your security plans, your plans for cultivation, your plans for production of derivative medical marijuana products, and look at kind of compliance points. It's largely a compliance exercise. Another important aspect of the management and operations phase that the state looks at is they conduct thorough background checks of everybody associated and anyone investing or contributing capital to the Green Lady. They successfully completed that phase, and that on September 15th, which signifies the completion of that phase 2017, they were invited back to what's called the siting profile. And that's where we stand today. The siting profile is an important part of the application process. It's where the state will defer to local municipalities. In this case, we have the honor and the pleasure to be before you to be asking for a letter of support or non-opposition. and that will allow the Green Lady to proceed in the application process. And I'll get a little bit later, I'll kind of talk about the next steps that we would have to do after this, including obtaining a special permit via the planning board, but there's other state hurdles that we'd have to kind of achieve before we can move forward. I know Michael talked a little bit about the location. I want to touch upon that a little bit. Again, it is 11 Amelia Drive. It's very well suited. Is a former medical facility and has enough adequate space for the small dispensary and cultivation that will be taking place in the facility. We will have to go, but this is the first stage of the local process. The local process typically should be a community engagement process whereby we are earning the trust of the community and going through the process and being as transparent as possible, and that's absolutely what we've been doing and will continue to do. A couple of things we want to point out about this group in particular. Nicole and Rupert are very committed to a environmentally friendly facility consistent with kind of the virtues of Nantucket. That would include LED lighting, installation of solar panels to offset electric consumption, which is expensive on the island, and then recycling of water. So these are just some things. And that's really kind of part of part of what they want to do is focus on environmentally kind of sustainable use in the medical marijuana space. Uniquely, they are the first, would be, if they're fortunate enough to get a letter here today and proceed in the state process, will be the first minority and women-owned dispensary in the Commonwealth of Massachusetts. This is an issue that's kind of facing the marijuana industry nationally, which is a lack of diversity, a lack of women ownership. We do have another woman-owned dispensary, but not minority-owned in the Commonwealth to date. So this would be the first of its kind, and just kind of makes them unique. A couple issues about zoning. This isn't the correct zone. There are issues about, sometimes there's setbacks. There can be setback issues. We've looked at this facility. We are confident that's not within 500 feet of schools, daycare, churches. Now DPH has a default, which is where children commonly congregate. This is really a local siting issue. We are aware, partly because our opposition, we understand there's another dispensary in town that's going to raise the issue that there is a ballet studio nearby. We have looked at that. It is kind of twofold. I just want to address it. One is it's not focused on children's activities, and we do not believe, and we are confident that it is not going to kind of falls into what DPH determines where children commonly congregate. Secondarily, as a legal matter, and I'm not sure, I'm happy to get into the details, but as a legal matter, the default setback, which is 500 feet from where children commonly congregate, applies only in the instance where a city or town has not adopted any local siting requirements. In the case of Nantucket, Nantucket has adopted local siting. They've determined a zone. They've determined a special permit process. And in that case, actually, the DPH default rules do not apply. Now, this is an area of confusion, and I'm happy to answer any questions about that, but I just want to kind of get ahead of that issue in anticipation of it being raised by our opposition. Highlighting a few, and Madam Chair, if I'm going too slowly or too quickly, please let me know. I'm not proud, so I'm happy to speed it up or slow down. Thank you. So with respect to just a couple highlights on security, we're fortunate in the Commonwealth of Massachusetts to have the most, in my opinion, the most comprehensive security most comprehensive regulations relating to medical marijuana in the entire country, which is, and then specifically as it relates to security. And Michael already mentioned that we had the opportunity to meet with the chief and present our plan. There was some feedback, some constructive feedback, and we adopted some of that feedback. But a few highlights: all dispensaries are required to have redundant alarm systems that will be in place. We will have interior and exterior high-definition surveillance cameras. They're not going to be necessarily visible, or they're not going to be an eyesore, but they will be honed in on every aspect, interior and exterior of the facility, and really the ability to focus in and capture images and keep the area secure. I'm going to go to the next slide to just kind of some more points about security. These are all taken from the regulations, by no means exhaustive, and certainly we do have a security plan that kind of lays out this in more detail. I want to talk a little bit about the patient kind of caregiver experience, and this is primarily driven by the regulations. And this is what the Green Lady what is going to occur should we be fortunate enough to site a medical marijuana dispensary at that location. Medical marijuana is only for registered patients in the Commonwealth. In order to get a patient card, you have to see a physician. It has to be a Massachusetts licensed physician, not a resident. It has to be a fully licensed physician and somebody that has a bona fide patient relationship with the patient. What that means is they have to conduct a history, they have to have a file on the patient, and they have to determine in their expertise as a physician or as a medical professional that the patient would benefit from medical marijuana for their stated condition. Once that happens, the patient is given a written certification that it submits to DPH along with identification. DPH will evaluate it, make sure it's valid, and several weeks later will issue a patient identification card. And that will be issued to the patient, a specific identification on it. And these are the only, a person with that card is the only individual, or the only individuals, that class, are the only people that are able to enter into this dispensary. And how it will work is, at the Green Lady, is that there'll be a kind of a I don't want to describe it as a ticket booth, but there'll be an outside entrance whereby there'll be glass and there'll be a door, and before they're even able to get into the building, they'll present their registered patient card. Then once they show their identification, they're buzzed into a secure vestibule inside the facility. Again, this is a secure vestibule where a second identification check takes place, requires a second form of identification. So you'll have your registered patient card and then a second form of state identification in that secure vestibule area. Once the security agent there, or the registered agent, we call them under the regulations, determines that that person is a valid patient, that individual has not exceeded its monthly maximum, or has not been doctor shopping. It is a dynamic system, which is great. Then they will be approved to get into the actual dispensary area. The patient will enter the dispensary area, will be offered, there'll be staff there, there'll be educational materials, there'll be an area to have a consult if the patient is uncertain, if they're new. And then there'll be the display cases, just to give you an idea. The regulations require that it's almost like a jewelry store. There's only one item for each kind of strain of marijuana or each product, and then it's only taken out one at a time. There's no touching, there's no obviously trying out, there's absolutely no consumption on site. And then if the patient decides that they want to purchase the medicine after determining what's appropriate, the medicine will be packaged in child-resistant packaging and ready with warning labels, opaque so you can't see into it, and that will be ready for the sale to take place, and then the patient will leave. Steps are taken to ensure that the transactions move relatively quickly. Obviously, there's security on site if the patient needs kind of access escorts to their vehicles or to wherever they're going. But the goal is at the beginning is to really kind of limit, to have the education. At the beginning, the patient visits will take longer because there's education, but as patients become regular, there's the ability for them to kind of come in less frequently if the case may be, depending on their condition. We provide these studies, just references to them. The Nantucket voters voted in 2012 75% in favor of medical marijuana. Nationally, we're seeing medical marijuana actually exceeding, in some polls, 85% approval ratings. Research has been a little bit slow because marijuana remains illegal under federal law. We wanted to highlight some studies. The study that I probably cite the most, or like to alert people's attention to, is the AMA study. That's the American Medical Association study in 2014 that found that states that enacted medical marijuana laws had a 24.8% lower mean annual opioid overdose mortality rate. And this is a really exciting and interesting evidence and research that's coming about that's showing that medical marijuana programs, when implemented, seem to be allowing for an exit and are actually helping the opioid overdose mortality rate. And we've seen that. There's a study published in the Health Affairs magazine in 2016 that talked about less prescription painkillers being prescribed in states that have medical marijuana laws versus others. Still a lot of more research needs to be done, but it seems that every day we're seeing more and more, learning more and more really positive information about medical marijuana, certainly about some of the CBD strains helping people that don't actually cause a high, which a lot of patients really want, and that the Green Lady really wants to focus in on. So finally, almost last but not least, I want to focus in, how is this going to benefit Nantucket? And the hope is that Green Lady, will benefit Nantucket by being a really responsible business that adds, that blends and really kind of adds to the character, but it serves an important service to the patients, people that need the medical marijuana on the island, and those that are visiting the island as well from the Commonwealth. We have wanted to put the best foot forward, and we put forward, the Green Lady put forward the maximum that allowable community host benefit to the town that we could under state law. And there was the new law that just passed capped community host benefit agreements at 3% of gross. This was very generous even before it, but this is the absolute maximum. We wanted to put that forward, and that's exactly what we did. We also included an immediate payment of $50,000 for improvements to the municipal parking lot. That was a feedback that we received from the town manager and from the chief, and we're more than happy to accommodate that and help improve the physical area around the dispensary in the abutting area. Taxes, we are a nonprofit. This does sometimes create confusion, but we are still paying full taxes as if we were a for-profit corporation. We will pay full property taxes. We will waive any argument that we have should it occur in the future that we somehow would not pay taxes. That is something that's in the host agreement, and that we absolutely will be paying taxes. Committed to we're committed to hiring locally on Nantucket. That is something that's important, I think, and I know that Nicole and Rupert are committed to. We estimate 15 to 30 full-time year-round jobs. Let's see here if I'm highlighting anything else here. I think that's kind of the highlights of the community host benefit agreement. We have come to agreement on it. I know that the town council there were certain provisions that they didn't like that we had added in. I can represent tonight that we absolutely agree with whatever town council wants, whatever the town wants with respect to that. We will agree to have those provisions struck. So just the final slide is why we're here. Certainly, thank you for having us. We were here to seek a letter of support or non-opposition. This is not a regulatory requirement, but it is an application requirement per DPH rule. So we will be unable to move forward in any capacity on Nantucket without this letter. It's really critical. I want to kind of point out that this is a long process. It is not easy to open up a registered marijuana dispensary or medical marijuana treatment center in the Commonwealth. This program has been in place since 2012. We only have, since the end of 2012, we only have 12 open dispensaries in the Commonwealth. The reason is that there's a strict regulatory, there's local siting, but primarily it's capital. That groups do not have the business depth or the capitalization to get through the process. I will say confidently that this group is fully capitalized. They have done a tremendous amount of planning around the medical kind of concept and thinking about what the needs are, what they need to execute and get it done. And I think it's kind of evidenced by how quickly they've moved through the state process, which is really quite remarkable. So they're fully capitalized. But I just want to wind up my long-windedness with just a few things of the next steps. So should we be fortunate enough to get their letter of support or non-opposition tonight, we'd have to submit a siting profile that would be reviewed by the state, and then we would wait for a provisional certification of registration. Provisional certificate of registration is not full licensure. It's not licensed. It doesn't really mean much other than it means that we can proceed in the process. At that point, we're in what DPH is called the inspectional phase. We'd have to submit architectural review plans. We'd have to start the local process in terms of special permit. So we'd have to appear before the special permit granting authority in Nantucket and obtain a special permit for the use. We'd have to build out the location and pass several DPH inspection points. And only then, have we successfully achieved all of that, would we obtain what's called a final certificate of registration. Final certificate of registration would allow for the beginning of the cultivation process. It's not approval to sell. Then we'd have several inspections by the department. If the local police or anybody in the town wanted to inspect as well, we'd be subject to that. And only then would we be, at that stage, DPH approves it, the health department in Nantucket approves it, we would be able to open up for sales to patients. So it is a long process. We're confident that we can get through it. We're collaboratively with the town and look forward to the opportunity to do it and give back, obviously, to the patients in the town. And with that, I'll wrap up, and unless Nicole or Rupert has anything else, happy to field any questions.
Jen?
I have a couple questions for Nicole. Thank you for coming tonight.
Thank you.
And can you tell me how many registered, how many DPH registration cards have currently been issued to Nantucket residents?
I think we know the number of the average statewide, of the population statewide.
I'm speaking, as you've done your business plan? So what assumptions have you made along those lines?
We don't know
and what-
specifically Nantucket, but the
Okay.
state knows that what percentage?
40,000 so far in the state.
40,000 cards, registered cards in the state of Massachusetts. They don't tell you how many are on Nantucket, so I don't know that answer.
Okay. Thank you.
Yep, I would-
If I could just add to that, so estimates, in the industry, most people estimate about 1 to 2% of the population. But to our knowledge, the state has not released data regionally. In fact, that was something that the Department of Justice requested, but I don't believe they're giving that data out. We can certainly try and find out if that was important to the board.
It's important to me, so I'd like to know.
I have a question, Donna.
I was just going to say, and how do you project that for seasonal residents that may have a card from another state? Or do they have to get one in Massachusetts?
So it's only for patients in the Commonwealth, no out-of-state
Massachusetts,
would be
okay.
allowed. So that,
Okay. Thanks.
Under point 12, it said edible, lollipops, gummy bears, et cetera, would not be sold. What edibles will be sold, if any?
I like to think that we have enough bad food in our lives already. I know I don't need any more candy or gummy bears in my life. So there are things that can be made that are much more healthful. Muffins, granola bars are very popular. So there's things that can be more healthy to eat overall, less calories, less sugar.
Like, just so you know, that's been one of my concerns. My thought on this all along, well, my other question then is, if the Cannabis Control Commission allows conversion from medical to retail, do you plan to do that?
That's a good question. We are focused right now on medical, and I think that medical deserves a lot of support. We really believe in it. I've talked to so many people who has helped, whether it's fighting cancer, overcoming seizures, opioid addictions. I've met a nice girl who finally got over anxiety and panic attacks thanks to CBD, which doesn't even have any psychoactive properties. So I really do believe in medical marijuana. Personally, I believe that there should never be a recreational dispensary if you're not willing to be committed to medical marijuana first, is how strongly I believe in medical marijuana. So it's a long-term process, and I mean, I have to see what Nantucket wants. I mean, I know you're going to might put a moratorium on until the end of 2018, and there's a lot to learn. So I'm interested in working with the town long-term and see what you want to do.
Yeah, because what I'm trying to figure out, it's a lot harder, it's easier to let the reins out than it is to pull the reins back. And so I'm trying to figure out, how do we, as a community, do this in a measured way? You know, we don't want, I mean, in my opinion, we're trying to slow down the whole partying thing and everything else. You know, the last thing we want to do is become the party central for 100 days every summer. And so how do we, as a community, deal with that? And, you know, so anyway, I haven't quite figured out, the laws are weird, and, you know, and so I would love to see no edibles at all myself. I just think that's, you know, and then if it seems to be working, then maybe we add them, but that's just one person.
Well, I know that there's a lot of people who are very sick, and they don't want to smoke in any way, shape, or form. They don't want to smoke. They have vaporizers today, which are much less smoke. They have all sorts of devices, but there's a lot of people who are very sick, and they just don't want to smoke. So there are pills, and there are tinctures that people can use too. But I agree with not smoking.
Right.
You know.
And I agree with that part too. I guess what I'm
Yeah.
I'm troubled with is what happens, you know, friends of mine who partake of this say sometimes there's no off switch with edibles. And some of the, you know, more severe impacts with youths in Colorado and France and places has been a result of edibles. and, left in the wrong place, or eaten by the dog, or whatever, eaten by the kids. And so I'm looking at it from that perspective. I'm not as worried about it in the medical, use. If someone really is sick and needs it and it's beneficial, I think we absolutely should do it. But in a retail, operation, I'm very hesitant. I just think we're opening a can of worms. And so anyway, I don't know how we get to that as a board or as a community. I just want to put that on the record again.
Well, one thing, I've worked closely with people in the town, and I get the feeling that everyone cares deeply about Nantucket and doing things correctly. And that's why when people say to take things slow or to put the temporary moratorium out there, I know it's because you are trying to do things correctly and take your time and make important decisions. So those are good questions, and I agree with taking the time to do whatever you decide to do.
Along the same lines, Matt, there's kind of two questions. One of my first initially was number 11 in the host community agreement regards adult use operations, and the last part of it, which basically asks the town to come to you first before talking to anyone else regarding any adult use operations, which, does that sound familiar?
Yeah, it does,
Yeah.
and I'm happy to address that. We've actually agreed to just get rid of the.
Okay.
Yeah, we've agreed to
Okay.
get rid of that.
So, and then that, Matt, just keeping this more medical, I believe, but I'm not entirely sure there's something to do about July 1st, 2017, and if you don't have a license, some sort of provisional license before that date, then you can't convert to recreational. But is that something that sounds familiar to you, Katie?
That sounds like a Katie question.
Yes, exactly.
I remember that too.
Good evening. Katie Lockman, KP Law. So there's language in the Act that addresses the situation you've described, which is anybody who has a provisional license as of July 1st of 2017. Any bylaw that is enacted with respect to recreational marijuana cannot preclude anybody who had those provisional licenses from applying for a conversion and getting licensed to do that. In this situation, this applicant does not have a provisional license as of that date, so that provision would not be applicable to the applications that's pending before you this evening.
Do we have any on Nantucket who have received a provisional license prior to July 1st?
Yes, you have
Okay.
one applicant.
Thank
Yeah.
you.
Katie, sorry,
Yes.
I know this is kind of a big question, but could the Cannabis Control Commission come out March 15th with different rules that could allow someone, could they change that date? Oh, if you had a provision, if you were registered by this date, could that be changed, or is there already rules set in place where this situation like Green Lady could not convert into?
So generally, regulations are consistent with the act that was passed, whether they're pursuant to. So I would imagine that if that date was going to change, that would require some legislative action. Again, as we've discussed before, there's a lot of big question marks hanging over the regulatory scheme that will be eventually enacted with respect to not just the recreational side of things, but things are also changing on the medical side of things, and the current procedures that are in place. Some of that may be up for further amendment, regulatory amendment down the road. But for right now, the regulatory scheme that's in place that these applicants are proceeding under is pursuant to Department of Public Health regulations that have been in place for some time.
Are you satisfied with the host community agreement at this stage?
Yes, so there were two provisions, I believe, that are highlighted in your copy. The indication from the applicant is that those can be stricken. I wasn't necessarily advising against them. It wasn't something I could authorize without you weighing in. If you have strong feelings on either one, certainly they were just further policy considerations that needed to be highlighted and brought to the board's attention from my perspective.
Matt?
I have another question. The two host agreements are somewhat different in how they are, payment is derived. Is that because the laws changed between host agreement 1 to 2, or?
So the payment procedure that was proposed by Green Lady, we we didn't alter it to make it the same as what had been previously approved. We just submitted what they had proposed. It is consistent with the host community agreement provisions of the new act, which caps the community benefit payments to 3% of the gross revenue. So it is consistent with the state law on that, in that area.
From a legal perspective, if one person has something that's different than the other person, is there any recourse one way or the other? Let's say, number one ends up being $20,000 a year and they're paying $50,000 a year. Does someone have a recourse against the town?
So I believe there's language in the agreement that is before you this evening that basically provides that if the Green Lady, as an applicant, later enters into a host community agreement in another community that has more favorable terms than what they've negotiated with you this evening, there's a reopener clause that would allow you to reconsider the more favorable terms that they agreed to in another community. We have taken the language out. One of the provisions we're taking out is the one that goes the other way and requires you to give to reopen this agreement and give them a benefit equivalent to what you have negotiated with anyone who comes in the future. And we also have taken out any language that would require them to, or allow them to challenge this agreement based on what was approved prior to any other prior applicant. So it should stand on its own with respect to the terms.
Does the first agreement stand on its own with respect to the terms, if they're both different?
I'd have to look at that language again. I don't believe that there is, I think the terms, the financial terms in this agreement are more favorable to the town, so this is not something that, I mean, if you had negotiated terms that required less payment, then the reopener from the prior agreement may have been triggered, but because the financial terms, I believe, are...
But you see my point. I just
Yeah.
want to make sure that we're consistent with both applicants and we don't
Certainly.
open the town up to anything.
Yeah.
And the only point that I'd make to that is that in the one that we've already have with Mass Media, it looks like we have kept the wording that would allow, it says, number 4, in the event that the town enters into a community benefit agreement with another RMD applicant, or in the event there's a material change, then the party shall reopen this HCB and negotiate an amendment. So it does seem that that part of it at least would be inconsistent.
So that's with respect to the prior agreement that you've negotiated. That language is not present in this agreement.
So we've taken it out
So you
this
may have to revisit Mass Medi but that language is not present in this agreement.
So if you could turn your attention to the letter of support that is in our package. And I'm a little confused. So it says, at a duly posted public meeting on tonight, voted the vote to provide a letter of support or non-opposition. Are those two distinct, either support or non-opposition?
Yeah,
Okay.
that's the official term that's used
No, I understand.
in
So we're voting on either to support or, what about a letter of opposition? Where is that in the mix here?
If you're not going to issue a letter of support or non-opposition, you don't need to issue a letter of opposition. You would just not issue
So if
the letter.
So this would take a majority vote, I assume, of tonight to provide a letter.
So that date, the date that's on there, I mean, if you voted tonight, then it
No,
would
I'm
be...
saying, assume we vote tonight.
Yeah.
We need a majority to send a letter of support or non-opposition.
That's
And
correct.
if we don't get a majority, then nothing gets sent. It's just kind of, okay, thank you.
Yes,
And without a letter, they cannot move forward?
that's correct. It's a requirement of the next licensing stage with the Department of Public Health, and failure to issue a letter would basically stop this application from proceeding.
And we have one current applicant. And what's the status of that we've already given a letter of non-support or opposite?
So that applicant received a provisional certificate of registration prior to that July 1st date. I believe it was in March.
Okay.
There's a date in March that, for which DPH issued that applicant their provisional certificate.
So we meet the requirement of having one medical
For county.
per our county. Is that correct?
Well, Yeah, so if I understand your question correctly, this was pursuant to the requirements of the Humanitarian Medical Act that required there to be one in every county?
There've been so many changes, you're the expert.
Yeah.
My understanding was, if we had one, we didn't have to have more than one.
Right.
Is
So
that true or
That
not
language has been repealed. So there's no longer a requirement that you have one.
Okay. And there's no requirement that if we have one, we have to have another one?
That's correct.
Okay, thank you.
And just having that license is enough, it's not actually up and running, means that still counts as having one?
So they have been issued the provisional certificate of registration. They're in the next phase of licensing in order to get their final registration. My understanding, and perhaps town administration can speak more to this, there's an issue of a location. I don't believe that the location they originally proposed is still available or something along those lines. Anyways, they have submitted some changes of location forms based on my review of documents at the state level, but I'm not involved enough to know exactly where things stand with them.
I have one more question just about the letters of non-opposition. There is no time frame on them from the point of when we provide them to when you actually have to be up and running by? Is there any plan to do that, or if there's not?
There's a timeline in which you need to have completed your application and obtained a provisional certificate of registration. Once that provisional certificate has been obtained, and if it's obtained in the time requirement set forth by DPH, there's not a specific timeline that then applies with respect to when you would receive your final certificate of registration. I don't believe once you have the provisional, there's language that allows that provisional to expire.
Okay.
One more, I've got another question. What happens to either applicant if, well, the medical is going to be the medical. If we allow it, it happens. What happens if town meeting votes against, recreational? So let's say that we vote at town meeting and then we vote at the ballot box against recreational, retail. Mm-hmm. Are they out of luck?
In terms of their ability to convert?
To convert, yeah.
Yes, if there's a full ban that is voted by the town, then the ability to convert goes away with respect to anybody that has the medical license. If you restrict or limit in some capacity, that provisional license that was issued to your prior applicant, that is still in play with respect to whether they can qualify under that conversion clause in the act. And so if you're going to allow one if you're going to allow one recreational, they may have the ability to apply for conversion.
I just have a comment, and that's not related to anything legal, but I would just caution us as you review the medical marijuana studies. This bibliography is not in any way complete and really doesn't show the studies that have demonstrated a different perspective. Just speaking as one member of the Board of Health, we've had, because we don't really have that much of a role in this, but we've had some kind of casual conversations about it, and certainly a lot of questions in my mind personally about the medical efficacy of marijuana.
More questions?
Yeah, I have one more question. In this situation with Green Lady and 11 Amelia, I think I know the answer to this, is we don't know what the CCC is going to do. Could you have a recreational and a medical marijuana in the same building? Is that an unknown?
Yes, so the act seems to be set up to allow for that type of a sharing of location. Certainly, there are a few things that would be a prerequisite to such an operation occurring. Number one, your zoning would have to allow for both uses in the same district.
Right.
Number two, the applicant would have to be able to get licensure under both the medical regulatory side and the the recreational side. And there would likely be regulations that apply with respect to some sort of separation between the uses in terms of like separate entrances, or that's the way it's done in many other states, because you have a different, you're going to admit a different level, different kind of clientele with respect to the restricted sort of tax-free marijuana on the one side. You have to have that special, you have to have the medical card in order to access that, so it would have to be a separate, separately regulated,
Right.
separately managed side of the business.
Okay.
Madam
Other
Chair,
comment?
yes, I could provide some more information, I believe, with respect to town council and the position on the other applicant who's received a letter of non-opposition. I know that the town, and I think Manager Gibson can confirm, the town's received a letter from the property owner, from council for the property owner of that last location, indicating that that location is no longer on the table, if you will. It's no longer a viable location. So I think what that triggers is a new site study. They have to come up with another location. So that would address what you had thought you had heard. I think that letter is with the application itself.
And just to add on that, that would require that particular group, if they've lost site control, which is an important part, even though they have provisional licensure, for a change of location request with the department, it's $10,000. Then you have to appear before the select board and get a new letter of support or non-opposition, if the board's so inclined to issue it, for the new location.
I don't know if we should have.
But I would guess that our hand, if we allow you in the commercial district to get it, my guess is we'd have to allow someone else that we'd provisionally give it to before. I think we'd be, we would be seen as, what's the word? Yeah.
Are there more questions?
The applicant's not opposed to any other.
Don't understand
It's
that.
just that the town has identified that zone, and so the siting has been focused on just the zone that the town has identified as where these facilities should go.
I'm just a little uncomfortable to have an applicant speak to both what their interpretation is of town council and what their knowledge is or their interpretation of what another applicant is. If the other applicant is here and wants to speak, I think, and either rebut or comment, then they should be given the opportunity to do so.
Or Katie can correct them if it's on our side.
I think they are here if they wanted to say something. And now's your time.
I do have so Stephen Cohen, an attorney, as you know, I represent Mass Medispa, and I have a small presentation I'd like to do, but I don't want to step on the applicant's toes. If you want to let them finish, or should I start? Or do you want me to address a specific question?
How long's your presentation?
Like 45 minutes? Sure.
Did you want to say anything else before we
No,
just
I
hear
think-
what their situation is?
I think the board wants to hear from Mass Medispa, at least on that last issue that I think they can clear up.
Right, so I will, just to address the real estate question, is that, yeah, so Mass Medispa had a property under agreement, and for a variety of reasons, they determined not to move forward on that location. There are, I would expect to announce a new location very shortly. There's a application fee that we would have to go to DPH to change that application. We're prepared to do that. Mass Medispa is well-funded. It has the permit in hand. The permit is not revoked or lessened because of the change of location. It's just a different thing. So we're moving forward, or Mass Medispa is moving forward, and they don't have to start back at the end of the line to go through everything again, just for a change of location. I will be in touch with the town as soon as we are able to publicly confirm that location. So I do want to address a few things that were said. First of all, I think that Nicole and Rupert look like they're putting together a great product, and that this is potentially a good benefit for Nantucket. I don't want anybody to get the sense that Mass Medispa wants to have a monopoly and there should be no competition. It's just not that kind of a situation. My client believes firmly in medical marijuana and wants there to be, full access for the community. However, this is not like everything else. It's not like more restaurants or, whatever, where people have their choices. I think it's really important for the board to note that medical marijuana is only by nonprofits, and it's as a public health service from the state's perspective and from the community perspective. And the reason why there are limits here is they want to make sure that people succeed, or that the businesses succeed, so that, or the nonprofits rather succeed, so that that service is available. And I think one thing the board needs to be aware of is that DPH estimates, as Mr. Fine said, that there's 1% to 2% of the population in an area that would have a license. So Nantucket's official population is something like 10 to 12,000, and if you use various things, you might even get to 18 or 20,000. If we use the biggest number, 20,000, you're talking about 600 permits. Two dispensaries for 600 permits sounds like two failures to me. And I'm sure that you would agree that that's not enough permits. And in fact, you might recall, as the permits for this facility were originally going through the original DPH process, there were no other applicants. There was one other applicant that didn't go through the process. And the reason why is that everybody looked at the numbers from Nantucket and said it doesn't make any sense, it's too expensive to be there, and there's not, DPH isn't producing enough of a market. And in fact, my client is only really moving forward because they have other permits, and by combining that scale of operations, they're predicting that they'll be able to make it work. So I do think it is a significant and important consideration for the board to take into account, not whether you should be governing or regulating competition and taking a preference, but whether or not it makes sense to have 2 or 3 or any more than 1 until we see what the numbers are at 1. And I'll remind you that the community benefit agreement allows for you to have full access to the books and the numbers, so you will know, okay, are they doing 600 or are they doing 6,000 permits? So you will know right away whether or not it makes sense for the community to be able to have 2. Not whether or not it makes sense for there to be competition, but just, are we going to have a viable dispensary here based on those numbers? So I would suggest that it makes sense to wait and see where we are on that. And I think, Mr. Kelly, you sort of asked that question a little bit when you asked what their numbers were if they have those permits. You know, is there enough, not enough business for 2, but enough public need for 2? Because we don't want both to fail. So that's one issue. The other thing is, I would say,
I guess my question is there enough public need for any?
For any?
Any.
Well, I mean, so whether you believe in having it or not is a slightly different question.
So I didn't want you to put words in my mouth.
Okay. Well, I think if you're questioning whether there should be any, 2 is an even stronger question. So I would suggest that the board may want to consider the idea of, do we want to start with 2 out the door, or do we want to have 1 as a test case and then more later, you know, which later doesn't have to be that long. You'll know pretty quickly if there's 600 or 6,000 people coming through the door. We don't have to wait 5 years. So that's one thing. The other thing is that in terms of the host community benefit agreement, because the Mass Medispa agreement has a reopening clause, I would suggest to the board that regardless of whether or not you're satisfied with that current Green Lady proposed document, that you might want to hold off on signing it until we've determined whether or not the other document needs to be adjusted, because I suspect you'll be in a better position if you look at them in tandem. So that's something you might want to consider as well. The other thing is that the location of this facility, you know, so I got my teeth cleaned today at Dr. Davis's office, and I'll say I'm really sad to see Roy and Sue leaving town. I think that's a real shame, but you know, they deserve to retire, so that's good. But if you look, when you drive out of the office, you see right there the Go Figure Studio. The Go Figure Studio has bar classes and dance classes for children. They have not 1, not 2, but 3 sessions of children's classes. And I know from personal experience, because I filed the application at DPH, that they will not approve a facility within 500 feet of the Go Figure Studio. And this is, I don't know, 40 feet? So I made the argument to the DPH attorney that Nantucket has standards that let us get out of that. And they said, no, Nantucket has a definition of registered marijuana facility and allows it as a use in some zones. That is not enough. We are going to apply the state standards until Nantucket has its own siting standards. Just saying you can have a special permit for this thing in this zone was not considered to be enough to get out of the mandate of the 500-foot rule. And in fact, I had to go through every business on Amelia Drive and within 500 feet of my client's proposed facility and showed them this is the legal owner, this is their business, this is their website, this is, whatever. And we had to show that we were not going to hit that specific tenant. So I would suspect that you might want to ask the applicant, hey, can you do the same thing that Mr. Cohen did? Can you provide a list of everyone within 500 feet and show us that you're compliant? Frankly, I'm not sure that even if they get away with the bar studio, that the Artists Association is right down the street, and this applicant may or may not be within 500 feet of that, and the Artists Association has kids' classes all day. So I would suspect, but before you file give them a non-opposition letter, we might want to know where they are on the issue of being within 500 feet of a facility that services children on a regular basis. The other thing is that my client's current license is very nearby, and the DPH facility rules and your own proposed rules for town meeting suggest that they shouldn't be nearby, within 500 feet of each other, that you don't want to have a glut of these in the same neighborhood. So I'd suggest you might want to wait and see how that shakes out a little bit, because you don't want two on the same street, or at least your proposed regulations say you don't. The other thing is that this location has multiple uses on the same lot. 11 Amelia Drive has multiple buildings, and I think the board might want to consider whether or not it makes sense, or whether or not it's a good idea to have multiple uses on a lot, because your regulations suggest that you don't want multiple uses in the same building, or the proposed regulations. The other thing is, frankly, because we're having a town meeting in November where your regulations may or may not go into effect for a lot of these things, you might want to hold off on seeing what we end up putting in place for the rules. That might change at town meeting or it might not, and this may or may not be consistent with what's adopted in 6 weeks. The other thing is that this location is, I think, a really poor applicant for a planning board permit, and I say that as someone who's at the planning board all the time, and I would suggest that you as the board, Selectmen, might want to get a letter from the planning board asking whether or not they think this location actually makes sense. They don't have to apply for a permit, they don't have to get approved for a permit, but they might want to get you might want to get the board to weigh in the same way that the planning board will weigh in on zoning applications that are before other boards, that it doesn't issue those permits, but it will give advice to the zoning board on planning board issues. And I'm sure the planning board would, in the same vein, give you advice on whether or not they think this location is a good idea. I'll just give you an example. Mr. Fine said that they expect to have 15 to 30 employees. Well, that's 10 parking spaces under Nantucket's guidelines just for the employees. So if any of you have ever been to this lot, I don't know where you're going to have 10 parking spaces for your employees, never mind your customers. So I think that there's a lot of considerations, not whether or not they can get a permit, but whether or not this actual location is such a great idea. So I think the applicant has a little more information that they should probably present to you before you decide whether or not you oppose this applicant in this location, and I'd request that you seek that information. Thank you.
Can I ask a quick question?
Sure.
Does your client plan to convert to retail, if they have the ability to?
I don't know the answer to that question. I suspect the answer is yes, but there are rules that will be in place that will determine whether that's possible at the same site. And it's certainly something that we could discuss with the town, because the host community agreement requires that issue if it comes up. It requires a renegotiation if that comes up.
Can I just ask a question?
Sure.
So you were saying that the new location for your clients is close, but it's around the corner? Is
Yes.
it 500 feet? It meets all those 500 feet from the Go Figure?
My
Go
client's
Figure
location?
Yeah.
Yes.
And the only question I
new
have...
location.
The new location.
Yes.
Not the old location.
The old location also did meet it, but I'll tell you, so 27 Old South Road, we had a back and forth with DPH on, because 27 Old South Road is actually within 500 feet of the Go Figure studio, and we had to demonstrate to DPH that we could put the facility outside 500 feet and only have the parking within the 500 feet, and they were willing to accept that. That's how tightly they were looking at the issue.
And my only question, just because you made quite a few points about the 11 Amelia location, that in theory, if we gave the letter of non-opposition, they can always move location, much like your client did. So this actual location isn't as much of a concern if we give the non-opposition, or no?
Well, I wouldn't go quite that far, because I think you should look at the merits of this location. And they're asking for you for this location, so I think it's important for you to look at that. It's not just a letter for anybody saying anybody who's in the right zoning district can have this letter. Is the town in favor or opposed to or neutral on this location? And I'd suggest that there are concerns within your own regs and within the state regs that say that this location is not a great idea. And I'd suggest that you request that information from the applicant.
And so your client's then would have to come back to us with a new location, and we would have to look at it?
Oh, yeah, absolutely.
Okay.
If for a new location, we wouldn't go to the state without coming to you first.
Right.
Absolutely.
Okay.
Yeah.
Thanks.
Okay. Thank you.
I would definitely like to know about the 500 feet from children's classes, if you could address that.
Absolutely. Adam can address that. I know that he's touched on it briefly. And a couple other points just to respond to Attorney Cohen. What's coming before town meeting is not I don't believe it's to regulate the medical. It's to regulate the recreational. So for him to suggest that you need to wait to see what the town's going to do in 6 weeks is really not something that affects what the state has said for medical. We don't know, or he's not provided this new location, but he says it's so close to this location that it might be too close for the board to be comfortable. But if it's so close, then as Selectman Higgins suggested, well, is it the same question you have about the dance studio? But I think Attorney Fine can clearly say, based on his experience with the state on a number of these applications on the issue of the zoning and how that affects it.
Yeah, I'm happy to address it. And I just think, I probably shouldn't say this, but my thought is, look, we don't oppose having more patient access in Nantucket. To me, that was just a litany of, we want to be the only game in town. We want it all to ourselves. And by the way, we haven't really done a great job of executing. We don't have our location anymore, which really means that they stand in a worse position than we stand before you today. And I wasn't here when they presented to this board, but obviously we were trying to be as thoughtful as possible and provide you with as much information. So it does stick a little when they say, and I don't know if they did the same, if they presented enough information, because it seems that there's some inconsistencies. If our location's bad, why wasn't their location bad? I do disagree with all due respect to their attorney, with their legal interpretation, and I have done this. This is all I do is cannabis, and I've done it in a number of communities throughout the Commonwealth. I've worked with the attorney at DPH, who actually used to be with Copeland and Page, who's now with the commission, and this has been an area of confusion. But as it stands now, my interpretation, and I'll just stand on my interpretation, my experience, having dealt with this exact same issue in Arlington, where my client was actually cited next to a pediatrician's office and near other places, is that there is a determination of there's two issues. One is what constitutes a place where children commonly congregate. DPH has not given a clear indication of what this means. Okay, so whether or not this studio, everything we understand about this studio is that it is in fact geared towards adult use. And we don't believe that it would qualify as a place where children congregate under DPH rules. Secondarily, probably more importantly as a legal matter, the setback rules, and DPH issued guidance on this, and guidance was issued to the town council in Arlington, because I dealt with the same issue, as to when DPH default rules apply. And I say default rules because DPH's rules are the ones that say whether or not the 500-foot buffer applies. Unless a town isn't. So in this case, the town hasn't enacted local siting. In other words, they've addressed a medical marijuana zone, and they've addressed the place where they want them. They've also put forward a special permit process for it. In that case, there's actually no default that we're bound to by the state. In other words, there's no setback. And so I disagree when the council says that we're going to go to the state and that the state's not going to issue our license. Of course, I could be wrong, but in that case, we won't get it. But I'm high degree of confidence that we're going to go to the state, and it's not going to be, there's not a siting issue. And so we believe that we're fully compliant with the zone. We're in the zone. We're compliant with DPH setbacks, and there's no local siting requirements in place here, no setback distance requirements here that we'd be violating. So I'm confident and respectfully disagree with their interpretation. I'm happy to kind of brief the board on the issue further if they'd like, and certainly speak with Copeland and Page. I don't know if they, have a position on it, but I'm happy to.
So there has been some guidance issued by the Department of Public Health to municipalities with respect to the question of the 500-foot buffer, and the facilities in which children are gathered or commonly congregate. And the DPH guidance that was issued with respect to this provision of the regulation talks about facilities in which children are gathered for a particular purpose in a structured and scheduled manner, or which are dedicated to the use of children, such as playgrounds, youth services programs, daycare centers, youth sports facilities, dance schools, and gymnastics schools. That's in the DPH guidance with respect to determining where places children commonly congregate are. There's further in that guidance, it talks about municipalities may set their own local siting requirements. That's the term that they use. But if they do not, the default buffer zone will be 500 feet distance described in the regulations. So there's a default 500-foot buffer in the DPH regulations. I will tell you that when we have advised municipalities on this, we have looked to their regulations to see if they have designated some other buffer. For example, some municipalities increase that distance to 1,000 feet. In that case, we tell them that their buffer zone trumps whatever the default is in the local regulation. Now, whether DPH has taken a more expansive interpretation of that since this guidance was issued with respect to what constitutes a siting regulation, I cannot say, but this is the guidance that has been issued to date from DPH on that issue.
And it clearly states dance studio.
Yes.
How do we get how do we get an expansion from 500 to some other number?
Well, that would be something you could adopt as an amendment to the bylaw. If
Okay.
you wanted to increase that sighting distance from 500 feet. And then there's also how that gets calculated, whether it's from property line to property
Right.
line or
Okay.
from facility to facility,
Okay.
the actual entrance to the facility to the property line.
So as town council, those are some of the kind of things I have an expectation personally that you'd advise us about. These are your other options, and that's news to me that we could take that. Maybe I missed that meeting, but, and if there are other opportunities for the municipality to do more things, I'd really encourage you to share that with the chairman and the town manager.
With respect to the regulation of medical marijuana, the zoning of medical marijuana facilities? Because this would be a bylaw amendment with respect to how you've cited for medical marijuana
Yeah,
facilities.
that's fine, whatever, so those are, when you say, we've advised other towns that have done this, and that would be nice to know what the options are.
Certainly.
So, okay, thank you, thank you.
Okay.
Pretty sure we did.
Excuse me, I just want to be clear too that, so I agree with that because I've read it and I personally went through it for this exact location for my applicant. But the important thing is they have not provided you with any information on any of the occupants of any spaces within 500 feet for you to make that determination. And I suspect that the Artists Association is going to fall within that 500 feet. And frankly, I don't know and you don't know what else might. So at a minimum, I think you want that information of who's there.
Madam Chair, recognizing the concerns that clearly that the board has, I don't think I'm misrepresenting the fact that we met with Andrew Vorse in the planning department, that this location met with his approval, and it was consistent with long-term planning. We recognize that you're asking or maybe asking for more information. Would the chair consider continuing this hearing so we can supplement what town or the board members are asking, or what the other applicant is suggesting you may want to look at?
This is not a public hearing.
No, but we
Okay.
don't.
We don't need to
have
continue
take
anything. We don't need to
action.
take, no, we don't need to continue anything. We can bring it up as
We-
another.
we
Only if
could
you
as an
wanted
agenda.
bring
more
it back in a
information to
couple
make
of
a more
weeks.
informed decision.
It might be helpful for us to kind of let them know what information we're interested in, some additional information.
We'd appreciate the opportunity to be able to respond to what
about,
you're asking for.
would you be willing to eliminate the edibles? I think that was a question that was raised. That would.
And again, I'm not so much worried about the edibles in a medical situation. I'm worried about the edibles in a retail situation.
But doesn't that translate from medical to retail when that gets that
When it-
conversion?
If
So again,
if and when they, I know.
To
And
your
that's-
argument
yeah.
about it's easier to, hold them back now than rain them out, I think we should have the most stringent standards that we think, and I agree with that on medical marijuana. I mean, on the edibles, especially when it's hard, you can't, so, plus you don't want another bakery in town making muffins.
Maybe I'll apply and make them.
Not proposing adult use or recreational. We would
My
hope that the board would
biggest
consider on the
concern is
medical
anything
part.
that has to do with children being dropped off for activities. And I'd like someone you're welcome to discuss this information, but I think internally we need to take a look at making sure that because of the locations of other existing businesses, that we're not making this so restrictive that there's nowhere that this can be cited that's within 500 feet of something. Because I know that other CN zones are very close to the school, and I mean, this particular thing, it was something that I thought of, that little girls get dropped off and little boys for dance right across the street there.
One of the concern I have is, to me, it's more advantageous to have it as a standalone structure, just by, we've all read or seen, this PBS specials or movies about Colorado, and, there tends to be, again, it's retail, not marijuana, not medical, but, there's long lines of people, and I'd hate to have, as if I were a business owner in that community or in that building, I personally would hate to have that as another tenant, a neighbor, because of the impact that it would have on my own operation. Maybe I have people living in that building, in the roof, in the attic or whatever. So my own preference would be a single business.
Get too far into what's probably the purview of the planning department in terms of those kind of queuing and parking and all of those parameters, but.
Yeah, it's not proposed to have 30 people on site per day, so the question of parking spaces, I think, is a bit of a red herring.
As they come forward, I'm interested in having them consider a single building.
Were you referring to that there's two buildings on the same piece of property? Was that your question, that there's two buildings on the same piece of property as an issue? Someone had mentioned that, I think, along the long line of, because one of the buildings isn't going to be for one thing, and the other building isn't going to be for something else. It's not going to be housing mixed in with a dispensary mixed in with a coffee shop. I mean, it's not going to be mixed use in there.
So which
It's the whole structure is all for the dispensary. It's dedicated for that.
all those, the entire, everything outlined in yellow?
Yeah.
Yes. Correct.
Okay, so there is no, I guess there was alleged that there were other neighbors that were occupying the same building doing other things.
No.
Okay,
The
that's
way
great.
it is now, there are, but it's not going to be that way any
Okay, well,
longer.
I'm glad I asked that, because that
Yeah.
really clarifies it, and I have no problem with that.
It's a shared driveway. It's
Yeah.
sort of shared with the people to the right.
Yeah,
If you go there.
I also did want to mention that someone touched on the zoning being very prohibitive. I have some people here that I worked with in the process to find zoning at all to do this. It's nearly impossible. It really is. The CN and the CI. Janina is on our board of directors.
Janine Franceschi. I work at Compass Rose Real Estate, and we're representing Nicole and Rupert in the sale. And when we started doing this months and months ago, we sent out about 450 letters. We first identified the 500-foot buffer around the Boys and Girls Club and all the baseball fields and the middle school and the high school, and really did our due diligence on trying to limit that 500-foot, the potential properties in that 500-foot buffer. And so what we did was figure out through zoning exactly what lots could possibly support this venture. And I sent out about 450 letters to different property owners. We came up with 3 or 4 really viable options, and this was just the one that worked the best. I mean, it was 2 properties. It was all an already commercially designated street. It's in the zone. It's already got 8 parking spaces. It just ticked all the boxes, and it was the one we ended up with. So, any zoning questions or anything other than that?
Since you have the map up there, I also
Yeah.
wanted to mention that when we met with Andrew Vorse, he mentioned that if we had just been on the other side of Amelia Drive, it could have been an issue because then there's all the residential houses in the background. And,
Right.
and those people, if any property, any potential dispensary had housing where people lived, you would probably get a lot of upset homeowners coming in too to
Right.
voice their opposition. So the fact that the police department and the empty lot is on the backside of it couldn't be more perfect.
Right. Right.
And I also did want to say, I was awfully disappointed. We've worked so hard, we've gone so far in 4 months, and the other dispensary has been at it 4 years, what we've done in 4 months. So it's really disappointing to hear people come up here and say things for no other reason than just trying to prevent us from getting into this business. It's already hard enough. We don't need other dispensaries fighting against us.
Madam Chair, can I,
Yes.
I'm trying to summarize my own mind. We have somebody who's had a license for a while, hasn't done a lot, we haven't heard a lot, who can convert into recreational at any time. We have somebody else who's applying, who's looking to do medical marijuana, which we don't know if they're going to go that way. So potentially, we could have 2 recreational and 0 medical marijuana in the long term down the road, potentially. Or we could have 1 medical, and the one, Medi-Spa, who's been there for a while, goes right in recreational. So what do we, as a board, what does the community want? Do we want medical marijuana? And if there's 2, maybe there's enough. I mean, we're not experts on that. You know, they can fight it out if there's 2. 1 will go right to recreational if there's not enough room in the medical marijuana space. I know we have to get through the kind of the weeds but the bigger picture is what do we want? Do we want medical marijuana?
But there's going to be a lot more demand for recreational. So if there's 2%, 1 or 2% medical, what is it, 20%? 30, 40% in the summer, recreational? I mean, I think that's where this whole thing is going from the state perspective. This is about money. This is big business, and this is, not necessarily you guys, but from the state's perspective, this is billions of dollars. And so, that's what we're up against.
So it was suggested that we put this over is 2 weeks an appropriate amount of time for you to
If the
come
board
back with
feels
more
that there's
information?
more information that would help you make a more informed vote, please, if you need 2 weeks, we would like to think we can be responsive in 2 weeks for what the board wants. We certainly, Adam will investigate and provide further clarity on the issue where if one facility could park their cars next to a dance studio, but they're saying this one can't be anywhere near it, well, let's get some information from the state. If there's a concern about market, and whether the market can bear this out, or if the Department of Justice is able to release the county information, as Selectman Kelly has requested, we can only ask for that and provide that. So if the board would ask for 2 weeks, and you think you can give us a comprehensive list of whatever concerns you may have, if that's enough time for you, we would welcome that opportunity.
Just a question for town council. Are we under any requirement to, when we get a request for a certain timeline, to make a response?
No.
So we could just talk about that. We could wait till after town meeting. We could wait till whatever. We could. And they would. Okay. Well, thank you.
But there's also common courtesy. I mean, I don't think
No, I understand.
they're spending a lot of time and money. I don't think we want to wait forever, so.
Yeah. If you
Thank you.
could get us some
2
further
weeks?
information on the questions that have come up.
Sure.
It definitely won't be on next week,
Right.
but 2 weeks would be the earliest.
I will meet with town administration and see within the next week if the board has provided a list of what you're looking for. And then we can pick an agenda that meets with your schedule of availability based on what you've given to Manager Gibson.
So are the board members going to give us questions then?
We're giving you a couple. One about edibles,
Yeah, I'd want to be
control
quite-
over edibles.
I want to be clear about what the questions are, because I jotted down control over edibles, the proximity of children issue, commitment to single-use building.
I think we've taken that off the table,
Yeah.
the single-use building.
Okay.
And
And-
another one is, who are the rest of those folks? Who is in the 500-foot radius or?
That's the proximity
Yeah.
to other uses.
And
Sure.
could we ask planning to take a look at what's in the CN zone that could cause this 500-foot issue? Just to make sure we haven't instituted zoning that's too restrictive.
And
And are they going to support this?
I will go back to Andrew,
let's get
and
him
I'll meet
on-
with him
I'd like to
again,
see-
because I
Leslie's here.
believe
I think
he's
we hope
very, very much in favor of this location.
I would love to
He's
see
not
that in
here.
writing.
I don't have it in
From the-
writing, but
from
I
the
will,
planning
I will
board.
attempt to
Yeah.
get that for you.
Based on parking and other things.
Right.
Because I don't want you, we don't want to run through all this and then find him opposing it. It doesn't make sense.
I think it's a fair representation that he was in favor of it when we met with him this summer, more than once. But I will do that for sure.
Thanks.
Thank you.
One more note, you may not have time, and it's not essential, but it might address some of Jim's concerns, and it was something that I started to do very cursorily, is talk to some of the abutters and see how they feel about it. And initially, they were supportive, but again, it
Yeah.
might help with some of the concerns of the board.
And as Chairman Holgate suggested, we've got a lot of planning board work to do where a butter notification is required, and that all is included within whatever type of permit might be issued. But we'll certainly do that between now and then.
And, I don't know if you want to reach out to Dr. McNabb to see if he had an interest in speaking on the matter?
From the Board of Health.
Board of Health?
Yeah. So I guess we'll take no action this evening, but we'll put it on
Thank you.
the next
And
available
we can agree to
agenda.
report on a date based on...
Thanks.
Yeah.
And I'm sorry, I'm
Information
packing up, but I
Thank you
have
very
to-
much,
I
ma'am.
have to get on the 8:45 boat tonight.
Katie has to go as well.
Let me see.
She doesn't have,
You can leave if you take Katie. That's.
Yeah, I know, I've just
Okay.
got to figure out where we can squeeze her in.
There's a roof rack, right?
All right, thanks. All right. We're going to move on to